Welcome to this session of the Risk and Compliance Exchange. My guest today is Sara McLean, the former Assistant Director of the Commercial Litigation Branch's Fraud Section for the Justice Department, and now a partner with Aiken. Sara, I've been looking forward to our conversation for a long time. I'm so glad we're able to make this happen. Thanks for joining us.
Oh, thanks for having me. I really appreciate it.
Now, I know we tried to make this happen last year at the inaugural Risk and Compliance Exchange. I know his timing just didn't work out for us, and I'm really excited to talk. I know this is weird about the Civil Cyber Fraud Initiative. Your former role at the Justice Department, you oversaw the False Claims Act. You looked at a whole series of the cybersecurity fraud issues. So let's start there. The Justice Department launched the Civil Cyber Fraud Initiative in 2021. Talk a little bit about what it is, why it was necessary. Give me just a little bit of history.
Sure. Yeah, so I was one of the assistant directors in the fraud section responsible for False Claims Act matters across the government, all different areas. Healthcare, contracting, cyber was a big part of the focus of what I did in the last few years, including the Civil Cyber Fraud Initiative, which was something that was launched in the last administration. Really a huge focus of the Justice Department on ensuring that contractors and grantees were meeting their cybersecurity requirements and using the False Claims Act to do that. It started as a big focus and sort of got launched that way. But then in more recent years and in the new administration, not that new administration, it is just embedded as part of the False Claims Act practice. And that's something that I've been leading at the Justice Department, and that is now still going on in my absence.
The False Claims Act was something I have to admit, every year when you guys at Justice Department used to put out the report of the number of procurement, I was always very excited to read it. I always look at where the procurement spending was. Why do you think cybersecurity became this kind of cutout? Why was this became such a focus area for the Justice Department?
Right. I mean, I think it's a few different factors. Um, Mostly it was just what was going on in the world in terms of cybersecurity risks. I think we're more and more recognized within the government and outside the government. But there was in May 2021 an executive order directing basically all government agencies to get their arms around cybersecurity, do what they could on this issue. At the Justice Department, there was a that launched a 360 review of cyber matters, and all sorts of different efforts within the Justice Department. But one of them was that using the False Claims Act in this way. The False Claims Act is, I don't know if your listeners know, it provides for treble damages and penalties for knowing false claims to the government. So it can be used and has been used for a lot of different requirements that come along with government funding. And so, I mean, in the Civil War, that was sawdust, instead of flour, lame mules. This was a new version of that sort of construct. That when somebody is providing the government something that is supposed to have cybersecurity and doesn't have what it should have, the False Claims Act can be used in this way. And really, I think the motivation was largely to improve cybersecurity, and also to just generally in the country to protect sensitive information, personal information, national security information, and to ensure a level playing field so that you didn't have some folks who were meeting the requirements and others who were not, to ensure that incidents were being reported to the extent the False Claims Act could be used around that particular issue, because the thought was that that would enable the government to respond to cybersecurity problems, and that still is really the impetus now behind the more recent enforcement in the last few months.
When we talk about cybersecurity and False Claims Act, it's mostly around contracting. The use of, for instance, hey, NIST 853 is required, FISMA is required. Now we're getting into cybersecurity maturity model certification over at DoD. Those are the types of things you all were looking at. Hey, did they say they met this requirement? uh-oh, we have evidence, or we were able to prove that they didn't actually meet it, and that's the connection. Maybe just go one step further to give us what you all were generally looking at, and or as you were receiving false claims allegations, what was it? A lot of that kind of provisions in contracting, but also the regulations and laws set up by Congress.
Yeah, exactly that. Provisions in contracting, regulations, and laws set up by Congress. And a lot of the matters that have been announced, and by the way, about half of the resolutions that have been announced have been since January in the current administration, about and half before then. So it's been a very significant push recently. Um, the matters that have been announced, a lot of them involve Department of Defense cybersecurity requirements, which are contractual, and they're regulatory. Regulations are incorporated into contracts that are signed. But the biggest other category is sensitive personal information, and again, oftentimes that's also contractual requirements. But agencies have been putting out more and more robust. More and more agencies, I guess, have been putting out more and more robust cybersecurity requirements, and all of those, can be the basis for one of these suits. But it's been what's been announced publicly has been a lot of DoD cases, and then a lot of other sort of odds and ends type contract cases where there was some sort of cybersecurity commitment that a qui tam relator, we can talk about that a little if you want, or the government alleged was knowingly not met.
Yes, Ketam, one of the few, and you'll forgive me if I'm wrong, Latin phrases I know.
That's right.
Uh, I throw that out when I'm at parties. Like,
It's
well,
good.
the Ketam lawsuit. People are walk away quickly. I wanted to ask you, Sarah, you mentioned this idea of uh, people of a lot around DoD personal information. This also has been a really big impetus to get contractors to come forward and kind of raise their hand to say, "Hey, we think we have a mistake. We want to mea culpa it," my second Latin phrase of the day, and they that maybe will lessen the penalties. Have you started to see that too, or more companies are saying, "Hey, we messed up and we're sorry," versus trying to fight the no, we didn't do anything wrong, all is well, go away, hopefully you'll stop pursuing us?
Yes, definitely a lot of that. And there is DOJ has policies of giving credit in False Claims Act settlements for self-disclosure, cooperation, and remediation, and that is definitely something that is that's available, and that companies have been definitely taking advantage of in this space. And it's been, highly touted in the press releases that DOJ has put out, that this is available, because I mean it's I think DOJ understands that there's more focus on cybersecurity than there used to be, and so there are companies that maybe didn't attend to this as much as they now wish they had in the past, who discover that they've got some kind of a problem, and want to fix it, and fix it going forward, but then also figure out how do I make it right, and in the past, and how do I avoid a whistleblower coming forward, a would-be whistleblower coming forward and filing one of these qui tams, throw around our Latin language. That is a way that private citizens can file a complaint under the False Claims Act and get up to 30% of the government recovery, if there is one, and the attorney's fees paid for their private sector counsel. So it's a huge, incentive for folks to come forward, and you don't actually have to have a lot of information in order to qualify for the reward. But in the cyberspace, what we have seen is a lot of people who do have a lot of information coming forward, and cybersecurity professionals within companies, in particular, who come forward and say, "Hey, I said that the company shouldn't do this, and nobody listened to me, and it happened anyway," and file one of these suits. So I think a lot of companies have decided that, and so there's a lot that goes into the consideration, but that it would be worthwhile to come forward and uh, come forward on their own, and get the credit that's available.
I always found it interesting to look at the key TAM piece because when you think about cybersecurity compared to maybe non-cybersecurity False Claims Act, it takes up probably evidence is hard. I would imagine at least evidence is harder to get for non-cyber related, right? Oh, do you have an email that says we're defrauding the government, or some sort of communication that says, well, oh well, we'll do a pass through and we'll, the it's a small business contract, but we're just not going to do the work. Like that evidence is harder to get with cybersecurity because there are logs and so much of it is based on did you implement this thing that you said you did or this control or this set of control. I'm guessing here, but is key tam more a key tam lawsuit or a whistleblower coming for easier is maybe not the right word, but they're people are more aggressive with it because the evidence at least seems easier to produce, if that makes sense.
That's an interesting question. I would say, um, no, I don't think so, because you make a very fair point about, well, one thing is that some of the allegations are that there are no logs. I mean, some of the allegations are that there is no cybersecurity, and that is something that, so there's that. But setting that aside, I think the fact that it's so highly technical makes it sort of harder. It would be a lot harder for the government to put together a case without the would be whistleblowers coming forward with their information. But there's a complexity to it that doesn't exist when it's. I know that the healthcare company I was working for was paying kickbacks to doctors, and there are emails about exchanged about that subject too. They're just easier for lay people to understand than the ones about the cybersecurity, where requires quite a bit of expertise to slog through it.
So did you and your team become experts as much as you can be in cybersecurity over the last couple of years? Do you know more about cybersecurity today than you ever thought you had to?
I certainly did with the government, and learned more than I ever had before, but also relied on experts, which is the same as in private practice. Cybersecurity lawyers who really know this stuff and can dig in and give advice.
I can only imagine like when the Justice Department came to you all and said, "Hey, we're gonna launch this initiative." You guys are like, like I'm sure you were familiar with cybersecurity, but the level of detail, the level of information probably just quadrupled in terms of trying to understand what you're doing. Let's talk a little bit about the work. I mean, how big is the civil cyber fraud unit? How many people focus on it? Or give me some of the inside of what happens in the Justice Department. Someone like help me understand what you guys do every day, for lack of a better word.
Right. Not me, guys. What my former colleagues do, but
Yes, yes, yes. What you used to do, right, for
what I
sure.
used to do, yes. So there's no separate cyber fraud unit in the Justice Department. There is a section of the Justice Department, the civil fraud section, that is sort of the mothership for False Claims Act cases. And that's about 130 lawyers or so right now. They work with the U.S. attorney's offices, and there are U.S. attorney's offices everywhere in the country in every judicial district. And in every one of those offices, there are people who do this affirmative civil litigation, False Claims Act work, basically. And so the group in Washington that I was with is sort of the mothership for the effort. Teams up with partners at the U.S. attorney's offices, and also teams up with the agencies, I mean, really critically. And there's a ton of cyber expertise, of course, in the government. As you know, you have people on your program, who do this day in, day out. Those people are available to the Justice Department to do these cases. And those are essentially the clients of the Justice Department in doing these cases and are behind the scenes guiding it. So certainly the DOJ lawyers who are generalists had to learn the area, but had a ton of resources to draw on.
It's interesting. Yeah, I mean, there's kind of there's a little bit of pulling back the curtain because we see the cases that come out and the settlements and the charges, but we don't necessarily know how the sausage gets made, for lack of a better word. And I think it's always interesting that it's not just one lawyer or a set of lawyers. It's a bigger group, and it's actually a great summary because I'm interested also how the civil cyber fraud division and the commercial litigation works with agencies, IGs, GAO, whomever. Give me that sense of that collaboration, because I see a lot of the press releases that says, the Justice Department, along with the, GSA IG or the Commerce Department IG, has done this.
Right. So the IGs are responsible for, fraud, waste, and abuse. So they are sort of the natural partners of DOJ in these investigations. They supply. So they sometimes refer matters to DOJ. Sometimes the agency itself will refer matters to DOJ when the QUITAMs come in. They get shared around with the agencies who are alleged to be the victims of the fraud. And then, the IGs assign agents. They will assign counsel. They will be part of I was going to say part of the investigative team, but that's not actually quite fair, because they will be most of the investigative team. That the DOJ lawyers are just members of it. But when it comes to agents, on the ground interviewing witnesses, auditors, all those resources come from the IGs. IG attorneys will help understand the programs, understand the law, find witnesses, and then when DOJ is ready to take some sort of, or the team is ready to take some sort of action, intervene in a qui tam suit and take it over, or decline or settle, they go back to the agency for a recommendation on how to proceed. And so it's really the agencies and DOJ are really in lockstep, um, you know, in these matters. DOJ is making the decision, but based on the recommendation of the agencies and with the total support of the agencies. And that's why when you see the press releases, you see the agencies, also putting out their views and thoughts. And um,
This is very similar. I imagine this works across the board: healthcare, non-cyber procurement fraud. This process, if you will, is this is not a separate process for cyber.
That's right. It's not. Although there is as I said, the cyber fraud work is now embedded in the normal False Claims Act work of the Department of Justice. But because it started off as this particular push to sort of put resources in this area, there's sort of a special amount of collaboration, not just case specific, but there's also collaboration on sort of what are the goals, how is this being carried out, what should the government do next in this area. There's more, much more, I would say there's more of that in the cyberspace than in other areas.
Oh, interesting. Is there some sort of, I'll call it a yearly planning meeting, a quarterly planning meeting, where you talk about what the trends you're seeing, the cases, or how does that come together? I mean, the IGs can throw a lot of cases or potential investigations over the transom, and you all are limited to how many you can do. How does that communication work, or how does the collaboration work?
I mean, regular day-to-day, communications among public servants. That's
All right, so I guess I was just interested to see if it was like, oh no, like every quarter we have this meeting where we talk about cases. I wasn't sure how formal it is versus, Sarah knows Mary over at the GSA IG, and you all just send emails and talk when necessary. I wasn't sure if there's anything more formal.
right. There are regular meetings, but smaller. I mean, the work gets done in smaller meetings, smaller interactions. Agency specific. Where it makes sense to get groups of people together. I mean, DoD has, for example, different partners for all the different services and different components of DOE CIO, or DoD CIO is involved. I mean, there's lots of different people that you might want to get together on one issue or another, that are not the entire group of federal government agencies with an interest in cyber, which is that is a larger group that can visit on these issues. But it's a huge government wide collaboration. Pretty it's pretty impressive.
I think people don't quite understand, to use your word, how impressive that is, that what it takes to get something through the process and do it the right way. And I know in Justice Department, you all used to say, well, the justice doesn't necessarily, they win a case, they settle a case. But I think we all on the outside, right, the non-lawyers look at this and go, yeah, they just didn't want to admit that they did something wrong. But if they're paying $10 million, $50 million, or even a few $100,000, someone made the decision that that's cheaper than going to court and try to prove their innocence. That just like they pay to go away. But it's always amazing how much work there is that gets done together. People don't quite get it behind the scenes. So that's why it's great talking to you.
There's, litigation risk, because that's what lawyers do, is recognize when there's litigation risk and, um, solve problems before they get out of hand and um, create even bigger problems. So, I mean, every settlement, every one of the cyber fraud settlements, as with every other settlement, does say there's been no finding and there's no admission of liability.
I get that, and I think that's an important way to kind of reach to get to that end result. But let's talk a little bit about some of those settlements. I know you can't be specific about cases, and I'd love for you to talk about the Georgia Tech Research Corporation. I know you won't, but let's talk about some trends. What are some of the things you're seeing more broadly about some of these cases that have come out? Especially as companies find themselves in the middle of these investigations. There's so much to dig into, but let's start with over the last couple of years. What are some of those big 50,000 foot trends you're seeing?
Right. Well, and as I mentioned, I mean, the subject matter of the cases, a lot of them are sensitive government information, especially DoD information, because the DoD has such very, specific requirements for what's supposed to be done around cybersecurity. And then, as I said, the other biggest category of cases is sensitive personal information, and that comes up involving a lot of different agencies, and it comes up quite a bit with healthcare type information. So that's one trend, that there are those couple of kinds of cases. Another trend is these qui tam suits by cybersecurity professionals, who come with a lot of information and a lot of concerns, um, from based on inside what they feel they've experienced inside a company. And a lot of times, interestingly, they feel like they made, or they say that they made an effort to complain, they made an effort to get things fixed inside, and were not listened to. That's sort of a profile, I would say, of a cyber fraud relator, that is a little different from a lot different, I would say, from other um, types of qui tam relators that we see, and suggests that there might be some opportunities for companies to sort of head that off by managing employee complaints differently. Um, we have seen, in some of the more recent announcements, especially some other sort of new types of fact patterns. And what happens is, when announcements are made that DOJ has pursued a matter and has resolved a matter, that often leads to the qui tam relators and their attorneys sort of finding more matters like that and filing them. And so it'll be interesting to see if these sort of newer fact patterns yield more that are similar. But medical devices is one, and then qualifications of cybersecurity professionals performing on government contracts is another. So those are some of the sort of things that I see forthcoming.
Is that fairly typical where the Justice Department settles with a company and other people start to kind of pile on, not on that maybe the same company, but similar to your words, fact patterns? Do you see that in other parts of false claims, or is this maybe something that was, again, a cutout of cyber for some reason this kind of took hold?
No, I think it's very common, and I mean, also, it's common, that for the suits to be filed over things that the government is announcing are priorities, whether it's Justice Department announcing it, or agencies like when DoD, even the press releases that you're talking about, when I know agencies come out and say, this shows the importance to DoD of XYZ. That's something that there's a very sophisticated bar of whistleblower attorneys that they see and notice, and perceive as something that the government's likely to pursue if they go ahead and file one of these cases. If for the whistleblowers, of course, as I mentioned, there's a huge reward if the government or the whistleblower gets a recovery, there's no reward, if there's no recovery at the end of the day. So, if you're in the business of filing these lawsuits, you want to file ones that the government is actually interested in and that are going to succeed. So yes, it's common that, if a certain, type of fraud allegation is out there and it's one that the government is recovering money on, that you'll see, suits filed in that area.
I kind of figured, but you just never know. I mean, cyber is such an interesting side, if you will. It's a kind of a flavor of a False Claims Act that, cyber's been around forever. There's been laws on the books since, the late 1990s. But just in the last, as you know, 4, 5, 6, 7 years, you've seen this really focus on it. So I don't know if anything else was different. The other one you saw was the cyber professional qualifications performing government contracts. When you all looked at those types of things, is it basically somebody saying to the government, "Hey, I'm qualified at this level," but in the end they're not qualified, or they hadn't been qualified? What are some of the things that kind of stood out to you when you looked at these types of cases?
Yeah, I think it's that, or um, I think it's basically that. I mean, the government puts out, and I think it's critically important for anyone doing business with the government who's especially signing a contract, agreeing to do something to make sure that they understand, especially in the cybersecurity area, since that's what we're focused on today, what it is that they've signed on to. And it is, it can be quite complicated. And it can be legally complicated, it can be technically complicated, but but signing on the dotted line without understanding it is just a recipe for getting into trouble. I mean, the False Claims Act only requires recklessness, not intentional fraud. So, I mean, that is another thing I could say is a trend in these cases, is there's a lot of evidence that shows, just what the government at least perceives to show reckless disregard, not an intentional let's set out and let's no. I mean, nobody wants to have bad cybersecurity. There's a lot of reasons to not do that besides just doing the right thing by the government. But there's a lot of just not sort of understanding the requirements, or not, and not putting the resources into understanding them, or not putting the resources into implementing them. And but when it comes to employee qualifications, it's the same thing. I mean, it just contract by contract what is actually required. But if a contract says that, there needs to be this level of education, or there needs to be this level of experience, or whatever it says, that is what, that's what needs to be, provided, or a company can get into trouble. And one thing we haven't talked about is that the False Claims Act, it applies to making false claims and causing false claims. And so it's not just the company that's actually directly doing business with the government that needs to worry, about the risk of False Claims Act liability, because a company that's downstream, like a subcontractor who's not submitting the claims to the government, could be found liable for causing a false claim. Or say an assessor could be found liable for causing a false claim, or a private equity company could be found liable for causing a false claim. There's individuals can be found liable, um, causing and submitting false claims. But it's, we've been talking a lot about contractors, but just to be really clear, it's not just the one company that has the direct relationship with the government that may have obligations. And it all just comes down to understanding what those are, and then making a good faith effort to comply.
I have to admit, in all the years I've been enjoying the coverage of the False Claims Act, I did not know the flow down, if you will. So, have there been cases that you can think of where a subcontractor, I think that's maybe an easy one, but a private equity firm, or even an individual has been found either liable or had to settle? I'm not saying that they haven't. I just
Yeah,
a
there have.
contractor I can see. Yeah.
There have. Yep, there was a recent matter involving a private equity, company, and actually involving a disclosure, like you said. I mean, that may be, and who knows, maybe that'll be a fact pattern that repeats itself as well. Discovering an issue, and bringing it to the attention of the government, and getting it resolved. I mean, there's no False Claims Act liability without, as I said, at least reckless disregard. So if something is, purely a mistake, it may be possible that there wouldn't need to be, any kind of, resolution. I mean, if there's been an overpayment or something, money could be paid back. But but companies are able to get a release from False Claims Act claims, by doing a False Claims Act settlement for an amount of money that is where they're being given credit for having come forward and for having cooperated and remediated, and they're able to work that out, with the government, determining the loss together, and doing it all in the absence of one of these quitams having been filed, which sort of ratchets up. It ratchets everything up considerably. So, I mean, companies are taking advantage of that, and I mean, a private equity company is a perfect example of who might want to. I mean, looking at, they come across all kinds of things,
Yeah.
and decisions have to be made about how to proceed, and that's one.
Sarah, let's do a quick break. We're going to come back and hear from an industry perspective. I'm Jason Miller, and we'll send you back to the studio for more from the Risk and Compliance Exchange.